Not every terror plot ends in a courtroom. Sometimes there is no trial, no public charges, and no conviction. That doesn't mean nothing happened. It means the system chose disruption instead of prosecution. So how does the UK stop threats without charging anyone? And why would it choose that path? The UK counter-terror system has two goals: protection and prosecution. Prosecution requires evidence strong enough to secure a conviction. But prevention requires reducing risk. Those are not the same thing. Sometimes intelligence indicates danger, but the evidence is not yet strong enough for court. Waiting may increase risk, so authorities use disruption. Disruption is about stopping capability, not proving guilt. Disruption is not random. It is structured and lawful. It can include arrest for non-terror offences, search warrants, seizure of devices, passport cancellation, travel restrictions, financial scrutiny, or targeted police intervention. The aim is to interrupt planning, break contact networks, and remove momentum without necessarily filing terrorism charges. Several legal mechanisms support disruption. Terrorism prevention and investigation measures, known as TPIMs, temporary exclusion orders, prescription of organisations, control of travel documents, monitoring requirements. Each tool has strict legal oversight, judicial review, defined limits, and time constraints. These are not secret powers. They are statutory frameworks designed for high-risk situations. The purpose is simple: manage risk while protecting public safety. So why not just prosecute? Because prosecution requires disclosure. Evidence must be presented in court. Sources may be exposed, methods may be revealed, international partners may impose restrictions. In some cases, intelligence is strong, but admissible evidence is weak. Charging too early could collapse a case or compromise sensitive capabilities. Disruption can buy time and preserve operational advantage. Imagine a suspect under surveillance, communicating online, acquiring materials, meeting contacts. If the threat appears to escalate, police may act early. They may arrest for a lesser offence, conduct coordinated searches, seize devices, or restrict movement. The visible outcome may appear minor, but the operational objective has been achieved. Capability has been reduced, momentum has been interrupted, risk has been lowered, disruption powers are not unlimited, they are reviewed, they are time-bound, and they are subject to legal challenge. The UK counter-terror system constantly balances public safety, justice, secrecy, and accountability. Disruption sits in that space, between intelligence and prosecution, between risk and law. So when a suspected terror plot disappears from the headlines, it does not always mean the threat was imaginary. It may mean the system intervened early, quietly, and lawfully. Not every case ends in conviction, but many end in prevention. And in counter-terror policing, prevention is often the objective. In the next video, we'll examine how terrorism prevention orders actually work and what restrictions they can impose.